Hello, this is Annalise Gear, your HR consultant and advisor. And today I want to talk to you about covert employee recording in the workplace. You know those situations where you're having a tense conversation with somebody and they take out their cell phone and fumble with it, and next thing you know, you're not sure whether you're being recorded or not. Chances are you are being recorded. The EOC says 30% of files that come their way actually have digital evidence to support their charges of discrimination. And defense attorneys also say that up to 50% of employees who come to file a potential lawsuit against their employer have also digital evidence. So the question is this legal? Well, in most states it is legal, except for 10 states in the nation. All 40 other states are what's called a one-party consent, which means that only one person who is part of that conversation has to give consent for the recording to be legal. Doesn't mean that eavesdropping is legal in those states. If you're recording somebody else's conversation, that's a different topic. What we're talking about today is the recording made by one employee of a conversation of which they are party to. The other 10 states are called the two-party consent, and they are places like New Hampshire, state of Washington, Vermont, Nevada, Connecticut, and Maryland as well. And in those states, both parties to the conversation, or however many parties are in the conversation, have to give their consent to be recorded for it to be authorized. So why does it matter if you are being recorded and it is legal? Well, for one thing, it's uncomfortable to be recorded when you're having tough conversations with employees. But most importantly, it could be used against you as legal evidence in a court case. So what can you do to protect your business? Well, it is somewhat difficult to prohibit clandestine recording by employee unless you have very good reasons to do so. For instance, if you have trade secrets to protect, confidential information, and proprietary systems, you might be able to limit the places where those employee recordings are authorized. But be careful. When you design a policy, you need to make sure that you don't run afoul of other employee rights, such as the ones governed by the National Labor Relations Board. For instance, if employees are recording what they believe to be an unsafe working condition, that's probably legal. You may not like it, but they probably have the right to do so. So what should employers do? My recommendations are, first of all, assume that employees record in workplace conversation, especially the difficult ones with employers, which might give rise to some sort of legal action. The other thing is inform your supervisors that in most states those recordings are legal, so they shouldn't get excited and belligerent if somebody's trying to record the conversation. And by the way, those supervisors, they may be already recording conversations with their own managers, so they might be aware of that already. But in any case, as an organization, you need to decide how you're going to handle the recording of conversation by your employees. And finally, once you've made that decision, make sure that you train your employees. And let me just put a brief plug here for you to consider doing refresher training for your employees. If you haven't done so in the past 2 years, and that was 2 years ago was 2014, it's probably time for a refresher. The Department of Labor has been very active in publishing new rules and regulations. The Employment Commission, the EOC, has also come up with new decisions that may affect your workplace. Then if you haven't trained your supervisors and your managers in the last 2 years, contact me and let's make this happen in 2016 refresher. Then, goodbye.